Fintechs and banks have been investing heavily in artificial intelligence in order to improve the efficiency of their operations. Unfortunately, relying on artificial intelligence can create inadvertent violations of consumer protection law. This in turn can result in fines imposed by federal regulators. Earlier this year, in May, the CFPB issued a circular discussing adverse credit determinations and how a reliance on black box algorithms and artificial intelligence can result in violations of consumer protection laws. So today I want to talk about how financial institutions are relying on artificial intelligence, the difficulties that this can create with the Consumer Financial Protection Bureau, and what financial institutions and fintechs should do now to ensure that they comply with consumer protection law. Data harvesting has become ubiquitous in the financial services industry. Financial services companies have access to very detailed information about their customers, and they make use of this information in a variety of ways. For example, in targeted advertising, and also when they're making credit determinations. One thing that they can do when they're deciding on credit determinations is to put that data into complex algorithms. And that can be helpful in making credit decisions. And often the developers of those algorithms don't even understand the reasoning that the algorithms are using to make specific credit determinations. That's why they're called black box algorithms. Relying on algorithms can make it difficult for financial services companies to ensure that they comply with consumer protection laws and regulations. For example, the Equal Credit Opportunity Act helps protect consumers against inappropriate discrimination when they apply for credit. In order to prevent companies from discriminating on an inappropriate basis, it requires the companies to give specific and accurate explanations of why they make the adverse credit determination. The problem is that if a financial services company relies on an algorithm, it can make it very difficult to explain clearly how the adverse determination was made. And now the CFPB has made clear that it intends to bring enforcement actions against companies that cannot clearly explain why they are making an adverse credit decision to deny an application for credit. And the actions are particularly likely if the CFPB determines that the result of an algorithm has a disparate impact on categories such as race, gender, national origin, or religion. Unfortunately, while the CFPB has made very clear its intentions to bring enforcement actions if disclosures about adverse credit determinations are found to be inadequate, it hasn't really provided very useful guidance on how companies that make adverse credit determinations should disclose the basis for those determinations when they're based on algorithms. And this is pretty disappointing because the CFPB 5 years ago requested comment on exactly this issue, how data and modeling techniques that are used in credit determinations should be made and disclosed. But nevertheless, there are some things that companies can do in order to reduce the risk of an enforcement action made by the CFPB. One is to document the process by which the disclosure is made based on the variables that go into the algorithm in specific credit determinations. The second thing is to invest time connecting the variables that go into the algorithm to the adverse determination explanation that is given, so that it is always possible to effectively reverse engineer it if a regulator asks about how the disclosure was made and how that disclosure was connected to the algorithmic process itself. A third thing you can do where possible is just to simplify the data set that is being used by the algorithm. If there's some categories of data that are not particularly relevant, it can simplify things to just eliminate those categories of data from the process. Finally, you want to consider potentially consulting data scientists that can look at your data set and see if there are any disparate impacts on categories like gender, race, or religion that are connected to the variables that are going into the data set. Because that can be a red flag for something that the CFPB may look at if it ever considers bringing an enforcement action based on the adverse credit decision disclosures that you've made. So it may feel like we're entering a brave new world of regulatory problems, but good news, I'm a lawyer. So if you do have questions about these issues that we've discussed today and how to disclose adverse credit decisions that are being made based on algorithmic models or artificial intelligence, give me a call. I'd be happy to talk to you.